Hey, it's Belinda J., your mediator, answering a frequently asked question. It's a topic. Maybe it's not exactly the same question every time, but it's the topic of, do people need to bring an attorney in? Am I an attorney? Do they need to mediate if they have an attorney? Things like that. And what I'm going to explain is literally just the difference between the litigation process, where you're in court, and the mediation process, where you're in my office. And you can bring your lawyer or not. The most common thing is lawyers send their clients to me and they don't come along, but they are available by phone if the client has any questions or concerns about something, if they should or shouldn't agree to it, if that would be damaging to them in any way. Their attorney is on board for that. It's also very common for people to have exhausted their funds to pay their attorney, and so then they're coming to me to try to get it wrapped up because they're already 15, 35 grand in. The numbers get even bigger than that, or maybe 5 grand in, and they don't want to spend any more money on litigation. In court, what happens, and this is a rough summary, the person that you've hired, or yourself if you haven't hired an attorney, speaks for 10 minutes. And then the other person, if they haven't hired an attorney, or if they have the attorney, speaks for 10 minutes. And then often the person who started the motion, the reason for this hearing, if they started it, they get another 2 minutes for their rebuttal. But that's it. You get 10 minutes, maybe 2 minutes of talking, and then a judge who is a stranger to both of you, but probably not a stranger to your attorneys, they probably played golf together yesterday, will make a decision on what's going to happen with your life. They'll tell you what you're going to do. The mediation process is a back and forth conversation. Even if you guys have a restraining order, or for any other reason under the sun, don't want to be or cannot be in the same room together, or even if at some point that I decide I don't want you in the same room together, maybe we're having a hard time not talking over each other, or maybe one of you has a question you want to ask me that you don't want to worry about what the other person is hearing or thinking when you're saying it, when you're speaking, we separate into separate rooms. Still a back and forth conversation, even though you guys are in separate rooms. I walk back and forth, and then I help facilitate the decision that you make for yourself. You guys come to an agreement, and it's not the negative connotation of settling, like you're settling for less than what you could have got in court, because usually nobody wins in court. There's things that you like that happen, things that you don't like, and it's always a mix of something because someone else is making that decision for you and telling you what you're going to do. So typically, the way our brains work, we would rather do something we didn't want to do if we got to choose it and we agreed to it, than doing something we didn't really want to do if someone tells us that we have to. So that's the biggest components about attorneys. They're always welcome, and there's a few attorney firms that flat out will not use me. They hear my name or see my name and they refuse immediately. No, we're not working with her. And my opinion is they don't want to work with me because I settle things. There's plenty of attorneys who are very happy to send their clients to me, whether they come and attend in session or not, and those are the ones that I see actually wanting to do the best job for their client and move things forward. There's a big difference between what happens in the courtroom and what happens out in real life. It is so common for people to come to me and say, oh, that court order is 2 years old, it's void. Or maybe it's 10 years old, or maybe it's 6 months old, but it's void because we can't even follow that anymore. Maybe somebody moved, maybe somebody got a different job, another baby was born, maybe there was a death. There's a million reasons that court orders are literally impossible to follow, physically impossible. And often people think that that order is void. It's no longer worthy or able to be upheld, but unfortunately it is able to be upheld, because if nothing has changed in writing, then that writing still stands. In opposition to that, mediation can always be changed. You can always come back in and have the conversation and say, oh my gosh, we moved, or we literally just changed our mind and learned new things and want to do something different. With the mediation process, you're allowed to. With the court process, you have to file for modification. There's a lot more involved, a ton more paperwork involved. And so the mediation process is a lot more friendly for those situations where you want your real life to look a certain way, not to have something on paper that says a certain thing.